Good afternoon. Natasha Minsker on behalf of the ACLU of California. I'm going to focus primarily on the costs of the proposed initiative. And to understand why the death penalty costs more, and particularly why this initiative will increase the costs of the death penalty, I think it's helpful to start with the analogy of the construction triangle. When you're doing a construction project, whether you're building a bridge or renovating your kitchen, everyone wants the same thing. We want a project that is high quality, fast, and cheap. And in construction, they say these are points of a triangle. You can't have all three. And in fact, as you get closer to one, you get further away from the other two. So if you want a high-quality bridge, you can have it, but it's going to take time and it's going to cost money. And if what you want is your bridge to be built really fast, well, you can do that, but you're going to have to give up on quality and you're still going to have to spend a lot of money. The same thing is true with the death penalty. The proponents of this initiative have decided they want a fast death penalty. And to get a fast death penalty, you have to give up on quality. And when you give up on quality with the death penalty, you execute innocent people, as Mr. Simpson explained. And if you want a fast death penalty, then you're going to have to pay for it. And so that's what I'm going to focus on. How much more will this cost? There's three areas where this initiative increases the costs of the death penalty in California. First, the judicial branch. As we've learned, the initiative takes the habeas corpus petitions from the Supreme Court and for the first time gives them to the superior courts. Those are our trial courts, our busiest courts. For the first time, our trial courts would have to appoint attorneys. That doesn't happen out of thin air. The trial courts have to actually have staff to do the work, to find, recruit, and appoint attorneys to make sure they get paid and deal with fee disputes. The trial courts are then going to have to actually review the transcripts, review all of the exhibits, review the briefs that are submitted, and actually for the first time they're going to have to write decisions. Notably, Mr. Scheidegger said the California Supreme Court actually doesn't write decisions in most of these habeas cases. And so for the first time, actually, our trial courts are going to have to actually write decisions in literally hundreds of death penalty cases. And habeas petitions also involve evidentiary hearings. That means actual time in our trial courts with judges, clerks, reporters, bailiffs. All of this takes staff and time. All of this costs money. And then from there, the initiative sends the habeas petitions from the superior courts for the first time to the courts of appeals. Right now, California courts of appeals have no role in the death penalty, and for the first time, they're going to have to review the decisions that come from the superior courts. So they're going to actually have to appoint attorneys because the attorneys appointed at the superior courts may have made mistakes. So new attorneys will be needed to review the work of the first attorney. And the courts of appeals are again going to have to read transcripts, again going to have to read briefs, review exhibits, and again going to have to write decisions. All of this takes staff and time and money. And then you get to the California Supreme Court. So our Supreme Court keeps all of the responsibilities for direct appeals under this initiatives. And now they have to review the habeas petitions that have gone through the Superior Court and gone through the Court of Appeal and gotten to them. So they've got to review the work of everybody up till then. And the Supreme Court has to do all of this in much less time, a fraction of the time of what they do now. If you want to do it faster, you have to spend more money. You need more staff. And as Mr. Schlesinger said, to actually decide the number of pending appeals, just appeals, in the California Supreme Court, in the first 5 years of this initiative, the California Supreme Court would have to triple the work they do on death penalty cases, work that's already a third of their workload. So the California Supreme Court would have to dedicate more time and more resources to these cases, which will take more money. In November of 2014, the Judicial Council came to the legislature and said, looking just at our trial courts, our superior courts, our busiest courts, just under current caseloads, the state of California is short 270 judges, just for the current workload of our superior courts. This initiative takes the most complicated, difficult cases in our entire judicial system, and it puts them primarily on those superior courts, and it asks them to do the work at a breakneck speed. If you want it to move fast, you have to spend more money. And in a system that's already overloaded and understaffed, you have to spend even more money to get the work done. The second area where this initiative imposes new costs is for the defense and prosecution teams. As you've heard, we have this enormous shortage of counsel. This initiative would require hiring literally 360 defense lawyers. Literally, 360 defense lawyers. And it's not just the lawyers you need to do these cases. You need investigators, you need mitigation experts, you have to pay for travel time, you have to pay for other costs. And you can't just increase the defense side, you also have to increase the AG side. So the Attorney General's office, their staff needs to be increased at an equal amount so that they can handle these cases. In 2008, the California Commission on the Fair Administration of Justice looked at this question: how much more money would we as a state have to spend to provide all the lawyers, defense, prosecution, staffing needed to deal with the current backlog of cases? And in 2008, the California Commission on the Fair Administration of Justice said we, the state of California, would have to spend $82 million more every year to properly staff these cases. $82 million. But that figure from 2008 is not going to be enough to get the job done under this initiative. For one thing, the Commission noted that the best option for dealing with the habeas backlog, as you've heard, is to increase staffing at the Habeas Corpus Resource Center. Right now we have a cap on the number of lawyers at the Habeas Corpus Resource Center. Unfortunately, this initiative closes off that option because it locks into the initiative that current staffing level of only 34 attorneys. So the only way under this initiative to provide new habeas attorneys is to use the more expensive method of using private counsel. The initiative also imposes these time limits. And when the Commission, the California Commission on the Fair Administration of Justice, did their math, that was assuming that the current time limits would be in place, not that we would have to speed things up. So $82 million a year doesn't come close to what's needed to implement this initiative. Right now in California, we pay our habeas attorneys $145 an hour, and we give them $50,000 for investigation, and they have 3 years to do the work. And if, with those parameters, only a small number of people are willing to do it. So if you tell them, actually, you're going to have to do it in 1 year, not 3, you're actually going to have to pay more money to recruit more people to do this. And so the costs from this perspective, from the perspective of recruiting attorneys, will be much higher than what we're paying right now. But let's just assume we go with the current figures. Let's just assume we stick with $145 an hour and $50,000 a year for investigation, or $50,000 a flat fee for investigation. Just to do the defense side in the habeas cases that are currently waiting would cost the state $105.3 million. $105.3 million under our current rate of pay just for the defense side. So this isn't covering the prosecution side, what we'd have to increase staffing at the AG's office, doesn't include the fact that we have to train new attorneys, doesn't come close to covering the costs that this initiative imposes. The third area of costs is housing people on death row. And this is where we respectfully disagree with our friends at the Legislative Analyst's Office. Under this initiative, death row inmates can be moved to any prison across the state. But this is different from this morning's initiative Because under this initiative, they're still death row inmates. They're still sentenced to death. And the security recommendations, the security procedures used for condemned inmates are fundamentally different. Every expert in prisons corrections will tell you it is not advisable to put condemned inmates into the general prison population. And in fact, our state auditor looked at this question. In 2008, the state auditor looked at death row housing and asked, instead of having everybody at San Quentin, would it be cheaper to move death row inmates to different prisons across the state? And the state auditor said, actually, no. It is economically not feasible to distribute death row inmates to prisons across the state because you have to replicate the security procedures in all those different prisons. So if you spread death row inmates across the state, all we're going to do is have to pay to build mini death row housing facilities in prisons across the state. And one thing I will also note is that these security requirements aren't actually entirely in the hands of the legislature or the Department of Corrections. They are subject to collective bargaining with the California Correctional Peace Officers Association. And so that is part of the reason we have the security procedures we do that lead to the high costs of housing, paying for the housing for death row inmates. The last item I want to touch on is the initiative's troubling changes to the process for developing our execution protocol. The proposed initiative would shroud the process for creating our execution procedure in a veil of secrecy by exempting the execution process from the rulemaking requirements of the Administrative Procedures Act. Under this initiative, the CDCR would have complete, unfettered discretion to choose how to execute people, including what drug, with absolutely no oversight. This is deeply troubling because in the past, when the Department of Corrections has had unfettered discretion in the area of executions, the department has violated state and federal law. The Administrative Procedures Act serves an important function of making sure that unelected officials who work in state agencies are not left unfettered discretion. The Administrative Procedures Act ensures that the Office of Administrative Law reviews regulations to make sure they comply with state and federal law and allows the public to participate in an issue that the public cares deeply about. And this initiative would remove all of those protections and cover the execution protocol in a veil of secrecy. This will greatly increase the risk that California has botched executions. And we know this from recent experience in other states. Arizona, Oklahoma, and Ohio are 3 states that exempt their execution process from administrative review. These are 3 states that have carried out horrifically botched executions. In January 2015 in Oklahoma executed Charles Warner. As the injection began, he cried out, "My body is on fire." The state later admitted that they used the wrong drug in the execution. Let me say that again. The state later admitted that the Department of Corrections used the wrong drug in the execution. That execution is now the subject of a grand jury investigation, and several people in the Department of Corrections have resigned. In January 2014, Ohio executed Dennis McGuire using an untested two-drug protocol. The execution took 24 minutes, with Mr. McGuire gasping and convulsing for 13 minutes before he died. In July in 2014, Arizona executed Joseph Wood using the same two-drug combination. They had to use 15 doses of each of the 2 drugs, even though their protocol said only use 2. The execution took 2 hours. One witness described Mr. Wood gasping for air 640 times. This is what happens when you exempt your execution process from the Administrative Procedures Act, and this is what will happen in California if this initiative moves forward. This measure will cost California taxpayers at least $100 million more each year than we currently spend on our broken death penalty system. We understand the passions and the deep, genuinely held intentions of the proponents, but the truth is it is poorly written and will make the matter much worse. Thank you.
Thank you. Again, are there any comments or questions from members of the committee? Senator Leno.
Madam Chair, would it be possible to ask Ms. Leaf from the LAO's office to come up?
It would be possible to ask, yes. Oh, she is still here. She was...
Thank you, Ms. Leaf.
Absolutely.
Can you just respond to some of the costs? Because I think the presentation differed significantly from your presentation.
Absolutely. So in terms of some of the costs, so one of the components that we think about in terms of when we do our analysis is we balance the intentions of the proponents and the opponents in terms of what we think will happen. So we have conversations with the departments, the stakeholders, and so we make adjustments for the fact, for example, in the first year, that it is pretty unlikely that we would have that batch of attorneys right off the bat. So that is one piece of an adjustment. We make numerous adjustments. We do also acknowledge that depending on how you implement it, and from our prior conversation, there are a number of questions to be answered, that it could be higher or lower than our estimate. The other thing that I will also have to say is we have actually been having updated conversations with all of the folks involved. And so as we move forward to the ballot, we are taking that into consideration, and we are further refining and updating our model. So that's kind of the attorney piece. In terms of the court piece, there are a few components there. We agree in terms of the different multiple layers of review. I think the other factor that we do consider as a piece of our analysis is the fact that for better or for worse, and we're not making a judgment call at all, is with the time limits, you may get petitions that are less lengthy. There are less items inside the brief that's filed. And so to the extent that you have shorter, more focused briefs, that reduces kind of the potential costs to the courts to process them. And so we consider all of those factors as part of our analysis. And so that's the court piece. I think the other piece was the prisons. Sorry, I'm just trying to recall.
Sure. No, you're doing well.
So in terms of the prisons, we do have conversations with CDCR, and that they've provided us with updated information where we have conversations with them, and they will ultimately be making these decisions about how they're going to house individuals. And so that is incorporated into our model as well. I think the other thing that I think is kind of an interesting nuance that is a little bit different is because the habeas petitions will now be filed at the trial courts, and I think we've heard kind of discussions about how in Southern California there are a large number of these petitions that would because it goes back to the original judge. So we've heard San Bernardino, LA, et cetera. So there is a potential rationale for moving individuals to some locations. And so all of that information is taken and factored into our analysis.
Madam Chair, if I may, I've got a...
Continue.
Okay, yeah. Thank you. So I want to recognize we've got some limited time here, but it sounds like you indirectly were making a positive reference to Ms. Minsker's triangle analogy, in that the briefs are going to be shorter, they're going to be less comprehensive. It sounds like they'll be of less quality because they've got a shorter time frame. Everything's going to be contracted. So you acknowledge that there may be a time savings, but something's got to give. You can't have the same quality.
I cannot speak to the quality. I think you have other folks that are more well-versed. I think from the analytical perspective, I certainly think that it's possible that you will have shorter ones. In terms of quality, I think that's something that will be determined by the courts when they're reviewing them. And I think that that is one of the larger questions. So, for example, when we talk about the federal courts, when they were reviewed, whether or not they would find whatever standards appropriate, or if they disagree and they would send it back to say, we don't think that this was an appropriate way of handling it.
If the current Supreme Court spends a third of its entire workload dealing with these cases, if they thought these briefs were unnecessarily long today, wouldn't they put their foot down and say, you're wasting all of our time? Be more concise. They wouldn't need an initiative to tell them, to have them give direction that we want concise filings.
I think that the Supreme Court would be better versed at answering that because it's from their perspective. We certainly do not.
This is just a layman asking a question. I mean, if there's excessive verbiage and content now that isn't pertaining to the issue at hand and could conceivably, as the initiative is suggesting, be reduced significantly, why wouldn't the Supreme Court want to save a good portion of 33% of its efforts currently?
Again, I would say it is certainly, we can't speak for the Supreme Court in terms of their logic and their plan. I think from an administrative perspective, we would know what we would say they should be doing, but we definitely cannot speak on behalf of their.
And let me say, I don't think that was a fair question. It was a perfect LAO answer.
It was not. It wasn't really a physical question either. So we need to stick with the physical question.
Yes.
I think, to the LAO.